Hello, and welcome to the DC Bar Pro Bono Center's webinar, Hiring an International Student, Master Visa and Green Card Options. I'm Christine Kulumani, Managing Attorney with the DC Bar Pro Bono Center's nonprofit and small business legal assistance programs. Thank you to my colleague, our Associate Manager, Lauren Paley, who has done the behind the scenes work to make this webinar today possible. Before we get started, a couple of logistics. If you're joining us live, this webinar will be recorded as a resource for you and to share. Additionally, right now you have access to the presentation slides in your GoToWebinar control panel under Handouts. If you have questions as we go, please send them through the questions box. We'll try to get as many that are topic appropriate as we're able. Remember that this is an educational webinar, so please keep questions general, informational, and not so specific or based on your exact facts that we're getting into individualized legal advice. Okay, on to today's webinar. We are joined by skilled immigration attorney Yalda Hajavi. Today, she is going to share some of her wonderful expertise with us. She received her law degree from Villanova, as well as her bachelor's degree, and is licensed in both Pennsylvania and the District of Columbia. As many of you know, the DC area has students and individuals from all over the world with valuable skills and abilities. But how can your organization leverage this talent in your work pool? Or what if some of these individuals want to break into entrepreneurship? Today, we're going to dive into some visa types, work authorization, and key considerations. And with that, Yalda, I'm going to turn it over to you. Thank you again.
Okay, great. Hi, everyone. Thank you, Christine, for the introduction, and thanks for everyone for joining me and the DC Pro Bono Center today for this presentation. I hope it'll be as helpful as possible. And like Christine said, I want this to be as interactive as possible. So if you have a question that pops up, put it in the chat, and I want to get through it as we're going through the presentation. So let's get started. I'm hoping everyone can see my screen. It seems to be the case. So today we're going to talk about hiring international students and mastering the visa and green card policies and immigration policies related to it. So for today's agenda, exploring visa and green card options for hiring international students. We're going to go over the types of visas, employment authorization, and what that actually means. Options for a green card, and go over some key considerations that you as an employer need to know when you want to onboard and retain an international student. So before we get into the good stuff about immigration, let's talk about why hiring an international student will be or could be beneficial to you as an employer. Well, first off, international students can provide a diverse perspective on a myriad of issues. They come from a diverse background. They've likely lived in more than one country before coming to the United States, and this allows them to have a diverse perspective on reaching conclusions for a problem solving, and perhaps even challenging the status quo, which we always know is never a bad thing. It's usually through these challenges that we have breakthroughs in the law, in policies, employer decisions, client decisions, and so forth. The second important thing about hiring an international student is they likely will have specialized skills. So when students come to the United States, they're typically coming to pursue a higher education or a next level of education in the US that's not otherwise readily available to them in their home country. So they already have skills that they just want to enhance or develop once they're in the United States. Oftentimes you see many international students being in the STEM related fields, so they have first access to cutting edge technologies and knowledge related to that. Another key important part about hiring an international student is their insight about the global market, which kind of leads into the diverse perspective issue. So again, they've lived in different countries. They not only are familiar now with the US market, but they're probably familiar with their home country and other countries that they've lived in. Language skills is another obvious benefit of hiring an international student. More often than not, they're fluent in more than 2 languages, and depending on your client base, you're going to have people that you deal with or negotiate with where having a second language is going to be beneficial. Now, doesn't mean that you can't communicate to your clients in English, but when we have someone in front of us that speaks our mother language, there's a level of comfort that we receive. So I actually see it with my own clients. I'm fluent in Farsi and I'm conversational in Italian, and when clients find that out, 9 out of 10 times, even if they've been living here for most of their lives, they want to speak the mother language. And connected to that, there's this huge cultural understanding that the student will have, now future employee will have if they're working for you, and dealing with a client that's from a similar culture or background. The other important aspect of hiring an international student is the competitive advantage that you as a company and employer can have. We see everywhere, especially in the United States right now, this movement towards wanting to have a diverse and inclusive work environment. If you are hiring international employees, you're really branding yourself out as being just that, an employer that values diversity and inclusion, and what better way to showcase that than hiring individuals from a diverse background. Depending on the footprint of your company, this will also help you gain a global presence and more credibility about the work that you're doing that perhaps extends beyond the state borders of the United States. And lastly, the cost efficiency. So having worked with other employers in the past that wanted to hire international employees or students after they graduated, I've discovered and learned through them that recruitment costs internally when you're running searches is pretty expensive. Now, I know that will really depend on the size of the company, but typically I've heard that it can be costly. If international students are attempting to apply for your company without you having to go through the recruitment process, well, you just cut down on those costs. And also, and we'll get into this today, I think there's this misconception that all of hiring of international students is going to require an employer to sponsor them and pay for them. That's not true. There are visa options where you're not legally obligated to pay for the legal fees and the government filing fees, and we'll go over that. And we'll also go over why, as an employer, it actually, in some instances, could be beneficial to you to want to sponsor them rather than have them sponsor them themselves for the green cards. But these are all just pros and cons that you as the employer will have to navigate and balance. So types of visas for international students. I think we mostly probably have heard of the F1 visa or the student visa, but there's also the J1 visa, which I'll get into in a second. The F1 visa is for a foreign national that's leaving their home country, coming to the United States to study. Their study can be for a bachelor's degree, associate's degree, or sometimes even an English ESL program, English for a second language program, a master's degree or PhD degree. For purposes of today's presentation, you're probably looking to hire someone that's here for a bachelor's degree, master's degree, and PhD. When students come here and they are finishing their degree or they've already completed it, they can be eligible for different types of work authorization. So if they get optional practical training, otherwise known as OPT, they can work in their field of study for up to 12 months after they graduate. So let's say someone's getting an MBA. After 2 years, they can apply for OPT. If they have a STEM degree, meaning that it's an MDA STEM where it's MBA focused on technology, or it's a science degree, engineering, mathematics, anything related to STEM, they actually get a 36-month extension. So, 36 months of STEM degree, so 24-month extension on top of the 12 months. So that's really 3 years of them being able to work for a US-based employer without the employer sponsoring them for their work authorization. So oftentimes I've heard when students are applying for positions, there's questions that says, do you need sponsorship right now? And my advice to students has been to say no, because you're going to have OPT. Will you need sponsorship in the future? That's a gray area, and we'll talk about why that's the case. OPT is for full-time employment, so it has to be over 20 hours a week. CPT, on the other hand, allows students to gain practical experience related to their field of study while they're still enrolled in school. So it can be year 1 of the MBA or the master's degree. It's part-time, so 20 hours or less if during the school year, or it can be full-time if it's over the summer or winter break. Think of it sort of as like a internship, but there's payment that can be made to the student. J visa. I do these often. I work with individuals wanting to come as a J1 visa foreign national, or get waivers to the 2-year foreign residency requirement that's attached to their J1 visa. But we won't get into the details of that. But the J1 visa is available to students, researchers, and trainees. So someone coming here to get temporary training in a field, a student that wants to come engage in a particular type of research or work, or a researcher that's more specialized and advanced in their fields. The J1 visa is unique because there are a lot of different parties involved. Aside from the foreign national, it's the US-based employer, and you agree to be the US-based sponsoring employer for the student or the specialist. There's a J1 sponsor program and the Department of State. The J1 sponsor program are programs, I should say, are designated J1 visa programmers that have been assigned by the Department of State to serve in this capacity. They really just work with the US-based employer and the foreign national to help them facilitate all the documents and everything that they need in order to be eligible to apply for the J1 visa. Once everything is corrected on the programmer side with the employer and the foreign national, the student can then, or foreign national I should say, can then go and apply for the J1 visa at a consulate in the home country. The exchange programs for this visa can be academic, or they can be a cultural exchange. And typically for J1 visas, after you complete your program, it's usually no longer than 2 years, you go back to your home country or must depart the United States within 30 days of the completion of your program, unless you apply for a waiver, which, like I said, won't get into today. So the J1 visa is not spoken about a lot, but if someone comes here on a J1 visa, they can work for you in J1 capacity, but you will have to be the sponsoring employer for them. You don't need to pay for the legal fees. You don't need to pay for the filing fees associated with it, but with the visa, but you will need to show that you're going to pay the employee that you're hiring the amount that is reasonable or makes sense for the position.
We have a couple of questions on OPT and CPT.
Yeah, go ahead. Let me go back to that.
Can a student apply for OPT or CPT, or are they automatic with an F1 visa?
So you have to apply for it. So when a foreign national student enrolls in school, they get to work with what's called a DSO, a designated school official. The DSO is in charge of all F1 related issues with the foreign national, and that includes OPT. So when it's time for them to be able to file for OPT once they're graduating, or they want to request to file for CPT, they go to their DSO and the DSO sets it up and facilitates it for them. And when they're on OPT or CPT status, their status is still F1. They're still an F1 student with OPT, F1 student with CPT. So they get an employment authorization card that allows them to be able to work even though they're on a student visa, because I'm not sure where the audience is in terms of their knowledge about F1s, but a big requirement is you cannot work on a F1 once you come to the US. It's strictly not allowed unless you have CPT or OPT.
Okay. And the other question we may get into in the next slide, but I'm not quite sure. If an employer wants a foreign national student as an intern with them, would that, in the capacity as an intern, would they need CPT?
Yes, yeah, they need CPT because they're going to be working. Now, if it's intern that's unpaid, that's a little bit different. But I have typically advised my student clients to still get CPT and, just make sure that they're not getting paid for it, if that's what the employer wants. I will say the employer's obligations and responsibilities when a student is on CPT or OPT is very minimal. They just need to show that they're working for them, and that the work that the offer letter that they give them proves that whatever work they're doing is related to the student's field. So, we're not hiring a nurse to be doing computer programming, for example. The employer isn't really involved in the process. It's more the school's DSO and the student that, of course, needs to figure everything out.
Okay, that is it on questions so far. Thank you.
Okay. So let's talk about the difference between work visa versus work authorization, because I've heard other attorneys mix this up. I've heard foreign nationals mix this up, and I've heard employers on the other side also mix these two up. So a work authorization is what allows a foreign national to work in the United States for any employer. So they get work authorization. It's called the Employment Authorization Card or EAD card. And with this card, they're permitted to go work for Amazon, for Deloitte, for the Washington Post, wherever they want to work at. The examples, like we just discussed, include getting EAD through CPT or OPT. Let's say there's an individual that's filed for asylum. They can apply for an employment authorization card. And again, they're allowed to go work for any employer. Then you have the green card, which we'll discuss. But when someone has a green card, they're automatically eligible to also go work for any employer in the United States. That makes sense, of course. Then we have the work visa. A work visa is specifically designed to permit foreign nationals to work for the sponsoring employer. The examples include the H-1B visa, the TN visa, O-1 visa, or the J-1 visa. In this case, let's say Amazon hires ex-employee from France to come work for them on an H-1B visa. Ex-employee foreign national can't come to the United States on that H-1B visa and on that same visa go work for Deloitte. Deloitte, they need to do what's called the H-1B transfer. So they're transferring the H-1B visa to Deloitte. So really, really important to distinguish the two. Same thing goes for the TN, the O1, J1. You're required for that particular visa, temporary visa, non-immigrant visa that you've received, to come work for the employer that's sponsoring you. And you know, the policy reasons behind it is that this employer has agreed to sponsor you. You can't just come here and go work for someone else. There needs to be a transfer for that to happen or a new visa issued for that to happen. Really, really important since the audience is employers today. And, you know, I know it's nonprofits or small businesses, so not sure what your employer compliance department looks like, but you must, if you're hiring foreign nationals, must comply with I-9 employment eligibility verification regulations. It's a tongue twister. I will provide some resources at the end where you can, if you don't have anything in place right now, go on the government's website, see what their suggestions are, and make sure that you have a system in place, because the last thing you want to happen to you is to get audited by the Immigration Service and the Department of Homeland Security for perhaps not complying with the regulations. I don't say that to scare you. It's pretty basic what you need to comply with. So I don't want to discourage hiring of international students because of this. But I'm just saying that these are responsibilities that you have to partake as an employer that's looking to hire an international student. So for example, require copies of what would make them eligible to be able to work for you. So require copies of their green card if they say they have it, their work authorization, or their visa approvals if, you know, it's you hiring them on an H-1B or O-1, which if you are, you'd be getting that as well because it's a dual representation agreement between the attorney and you, the employer, and the foreign national. But those aren't hard to ask for it. I had a horror story a couple of weeks ago, maybe a month at this point, where I had a call with an employer that had hired a foreign national, few foreign nationals actually, to do low-skilled work at their company, and they didn't have a compliance system in place. It turned out that the employee on our call told me that they were on a student visa. And I said, that's strange because I don't know how they're on a student visa, but I have a social security number and employment authorization when they told me they were on an ESL program, which doesn't allow you to get OPT. So I asked the employer later on to send me the I-9 record for this particular employee. It turns out that they had used someone else's social security number, someone else's green card. And this employer hadn't requested to see hard copies of the green card and work author, the social security card. Typically, you won't ask for the social security card, but you'd want to see the front and back of the green card, front and back of the work authorization to make sure that everything is stated is truthful. If you're an employer that's in person, require them to bring those documents in, make a copy of it yourselves, and give it back to them. These are all precautions we want to take for that 1% chance that there's a individual that is so desperate to stay in the United States, they will do anything. My heart also goes out to that individual and the population of people that have to do that, just because I know how difficult it is to have left some of the countries that our immigrants have left from. But you as the employer also need to protect yourself. So that's where being an attorney on both sides can be kind of difficult. But I really, really wanted to stress that, because the last thing we want is an audit from the government. All right, so let's talk about non-immigrant work visas and where you as an employer are required to sponsor the foreign national for their visa. So the most common, I think, typical one that you may have heard of is the H-1B visa. What you may not have heard of is that there are two types of H-1B visas. One is the H-1B cap subject, and the other one is the H-1B cap exempt. For the H-1B cap subject, there's an annual cap limit of how many H-1B visas are allotted to eligible foreign nationals. So 85,000 H-1B visas, 65,000 for a bachelor's degree, 20,000 for a master's degree or higher. And occasionally, the government will go through a second round of H-1B selection. It's hard to know when they're going to do it, but last couple of years they've been doing that, where they select more people. It literally is a lottery system. So you as the employer would work with internal counsel or outside counsel to register for the H-1B petition. You would register your employee that you want to sponsor and any other foreign national employees in a system online. Once selected, then we move on to the second step, where we have to prove to the Immigration Service, USCIS, that the person that you're going to hire is eligible for the job, and that you as the employer are eligible to sponsor them. You being able to sponsor them is really just, can you pay their salary? So we look at your tax returns, any other company data that shows that the company is making enough money to be able to pay the foreign national the prevailing wage. And the second step is, we also file the petition with USCIS and need to also show that the foreign national is eligible to work for you. So do they have the degree that you're requiring of them? Have they had the experiences that you're requiring of them? And all of this gets captured in what's called a employer petitioner letter, which a attorney would help you draft. Once you file, it's called, the form is I-129H. Once you file that with USCIS, you can premium process it. So you pay the government an additional $2,805 for them to review the case in 15 days. And I always recommend, especially for H-1Bs, to do that. Otherwise, it can take a few months to get those back. And with how quickly people usually want to hire and bring the foreign national in, or have them, if they're already here, switch to an H-1B, we can benefit from those couple extra $1,000. The duration for the H-1B is up to 3 years, and you can typically renew it for up to 6. And I say typically because there are special rules and provisions for foreign nationals that are from India. If they have an approved green card eligibility document, which we'll talk about shortly, they can actually renew it indefinitely, and I'll explain why. And if not from India, but other countries where they have an approved I-140, but their a green card eligibility document, but their H-1B visa is about to expire and they are not eligible to file for the actual green card yet, there's a provision in the law that allows them to renew it for an extra year. So H-1B visas, you, the employer, are obligated to pay for the legal fees and the filing fees. Legal fees can range anywhere between $3,000 to $5,000 for these cases, and filing fees, if you're premium processing, $2,805, and anywhere between $400 to $500 to $600, depending on the size of the company. The next type of H-1B visa is a cap exempt H-1B. So nothing different other than that the company filing for it is a university or higher ed institution or a nonprofit institution, which means that they are exempt from entering into the lottery. So no need to put the name in the hat and have a 50% chance of getting selected or not selected. No need to go through that. And you just file the form with USCIS, prove that you're a university or a nonprofit institution. And of course, same thing as the H-1B on the foreign national side, they need to show that they're eligible for the position. Once that's shown, and hopefully it's approved, they can start working for you. I did forget to mention, so if we're doing cap subject and the individual is selected and for the lottery and the case is approved, they need to start working for you on or after October 1st to start of the fiscal year. For cap exempt, they can start anytime. So if you're a nonprofit or a higher ed institution, the foreign national can start working for you anytime in the year. And same thing, up to 3 years, renewable, typically for up to 6 years. And again, you, the employer, are obligated to pay for the legal fees and the filing fees associated with the case.
So while we're wrapping up H-1B visas, are there restrictions on which nationals of which countries can receive these or apply for them?
No, there are no restrictions. And anywhere anyone can apply. And the wait period for the H-1B is the same for anyone that's applying. So we'll talk about how wait times are affected based on country when applying for a green card shortly. But for H-1Bs, there's no limit in terms of the country that's applying. It's more about eligibility as a foreign national to do the job that you're trying to do in the US.
Okay. And for the H-1B, are there certain types of workers only that are eligible? So for example, we talked about, for OPT and CPT, the work needs to be related to the student's field of study.
Yeah, so the legal term is that it needs to be a specialized occupation, which means that the individual needs to have a bachelor's degree or higher, and the work that they're doing needs to require a bachelor's degree or higher. But let's say someone was a computer programmer, a computer programming degree, and they have a master's degree in that, but they want to do work in AI, and you as the employer determine that, well, based on some of the courses that they took, but it's not necessarily the degree, and some of the other background that they have, they're qualified for this position, they can apply for the H-1B. So it just needs to be related. The degree needs to be related to the work that they're doing, but doesn't have to be exactly the same. And OPT is the same thing, by the way. CPT is the one where it's a little bit more specific, I would say. But even OPT, like I had a client that was a neuroscientist, bachelor's degree, data scientist, master's degree, and then she was working as a computational neuroscientist with doing AI work on OPT. So related, but not exactly the same degree.
Awesome. Thank you so much. And that's it for our H-1B questions.
Okay. So another type of visa, and I'll kind of going back to the H-1B, this is the TN visa is a visa where it's only available to a specific country, two specific countries. Employer needs to sponsor the foreign nationals work visa here as well. To be eligible for a TN, you either need to be from a citizen of Canada or a citizen of Mexico. And I'm stressing the word citizen because that's different than national. Citizen is you go to a country and you gain their citizenship, or you were born there. National is where you were born. And nationality is very important for the green card process. Not as much for the work visas that we're talking about today. So someone from India can move to Canada, get Canadian citizenship, and be eligible for the TN visa there. You must work in a field that's listed in the occupation list for the United States, Mexico, Canada agreements, like the NAFTA agreement. I think it's called something like that. The fields that are available are more narrow than for the H-1B. However, with some creative lawyering, you can have an employer's title or work, employee's title or work related to one of the types of occupations that's listed in this agreement. You must have the necessary education credentials and work experience required for the position. If you're Canadian, you can apply at a US port of entry with proof of your Canadian citizenship, the job offer, and evidence of the qualifications. Or if you're already here, you file Form I-129 with USCIS, and you can literally just go to the port of entry and get the TN stamp. So don't need to go through the consulate. For Mexicans, apply through a US consulate or embassy, providing similar documentation as Canadians would. It's good for 3 years and can be renewed indefinitely, but the job offer needs to remain valid. So you have to keep renewing the job offer for the position that you're hiring. And of course, the qualification has to be met. The visa is employer specific, so what we talked about earlier. Someone can't come here, a Canadian can come here on a TN visa, work for Amazon on a TN, and then want to do some side contracting work, self-employed, to gain a little extra income on their TN visa. That would be a violation of their TN visa, and I think they're barred for life for applying for it, but I actually am not sure on that, but we just don't want that as a foreign national to be doing that. So they must only be working for you and doing the work that was listed in the job offer. And again, the work that they're doing needs to align with the TN occupation category. And this is available online. What types of fields and areas are eligible for a TN visa. Unlike the H-1B, the employer is not necessarily required to pay for the legal fees or filing fees here. A lot of times they do, because they really want to bring in the talent and retain the talent. So, it's part of the deal that, we'll take care of these fees for you. But they're not required to, like the H-1B. Non-immigrant visas continue. So the O1A and O1B visa, and this is O1s are part of my niche practice. These visas are available to individuals who demonstrate extraordinary ability or achievements in their field. The O1A is for individuals with outstanding skills in science, education, business, or athletics, whereas the O1B is available to individuals with outstanding skills in arts, motion picture, or television. People that apply for these visas need to have a record of excellent achievements in their field. So whether that's through awards, published material about them, citations to their work, media coverage, presentations, publications that they've published themselves. It's a high standard to meet. So not everyone that's applying for H-1B is necessarily going to be eligible for O1. I do a resume evaluation to determine whether someone is in fact eligible for the O1 visa. But unlike the H-1B, no lottery, which is great if the foreign national applies. Employer doesn't necessarily need to pay for the legal fees or filing fees. So if someone is eligible for the O1, I do recommend for the individual and the employer to pursue it, just because we don't have to deal with the lottery system. It's also granted for up to 3 years, and you can get extensions in 1-year increments. Need to have a job offer from a U.S. employer or agent, and the work, of course, needs to be related to the area of extraordinary expertise. So can't have a physician come to the U.S. on an O1 visa and then them decide to be a chiropractor. It's just, the case isn't going to get approved. We need to show that the basis for their extraordinary skills and ability and their acclaim in their field is related to the work that they're going to be doing at the US-based company. I love doing these cases. They're very writing intensive, but that's the part of immigration law that I really enjoy. And yeah, I've done this for a lot of employers that they've loved doing that rather than doing the H-1B process, just because of that additional layer of having to go through the lottery system. And you can premium process these cases as well, so get it back in 15 days rather than 3 to 6 months. And the employee can start working for you as soon as they have the approval notice for the O1 if they're here, or if they have the stamp for outside of the country. They, of course, enter the United States with their O1 visa. Take a quick drink. So immigrant visas. So far we've been talking about non-immigrant visas, which means that people are coming to the United States temporarily, and once they come here, they work, they get their training, do whatever they want to do temporarily, they're required to go back home, unless they adjust their status to get a green card, or if they're applying for the green card right away, being outside of the country. So let's talk about green cards that require employer sponsorship. Employment-based green cards are referenced in the EB2 and EB3 preference categories, and also the EB4, but EB4 is mostly for, well, there's a whole laundry list of people that apply for EB4, but it's like people that work for the World Bank, the UN, certain translators, religious workers. You don't need to go through the process that we're going to talk about in this slide, but the employer needs to be the petitioning party for the employee for EB4. Well, let's talk about the EB2 and 3 because it's more common. There's different preference categories in the family-based immigration, employment-based green card immigration. So when I say EB2, that's a second preference category. EB3, that's a third preference category. And we'll talk about EB1 in the next slide. So EB2A and EB2B are available to individuals that have an advanced degree or show exceptional ability. So advanced degree is anything higher than a bachelor's degree. Exceptional ability has specific requirements that you need to show. So whether they have a membership in professional organizations, 10 years of experience in their fields, letters of recommendation from experts in their fields, and so forth. The reason these preference categories are important is because of what we call the visa bulletin. So anytime you apply for a green card application, it's a two-step process. First is to show that you're eligible. The eligibility form is Form I-140 or the perm with the I-140. And if approved, you can go and file for the green card itself. But different preference categories have different wait times of when an immigrant visa or green card will become available. And someone asked a question about the country-specific issue with H-1B. Well, that's a real issue in the green cards space for employment. China, India, Mexico, and Philippines are backlogged in the visa bulletin. Other countries, not as much, but depending on the preference category that they're applying for, there's more backlogs than others. So the EB2 category for all countries except China, India, Mexico, and the Philippines is more backlog, or less backlog than the EB3 category. So if your if your employee has a master's degree and the work that you want to sponsor them for would require a master's degree, I would recommend filing under the EB2 category rather than the EB3. EB3 is for skilled workers, professionals, and also other types of workers. For the green card petition, if you're sponsoring the employee, you need to go through the perm labor certification process. This is a process that deals with Department of Labor. First, you file with the Department of Labor a document that's called the prevailing wage document. So based on the minimum requirements of the job and the skills and degrees and certifications that you're requiring and that the foreign national has, you want to get a prevailing wage determination back from the Department of Labor that would require you to pay this employee the amount of money that you actually want to pay them in the future. So it's really, really important to hone down on the actual minimum requirements of the job. So if speaking Spanish is not a minimum requirement, don't require it. Also, languages requirements typically get an audit from the government because they're like, all right, it sounds like you're tailoring this job to the foreign national because they can speak this language. Unless it's like a translator company, then you really do need that as a requirement. So really important to work with an attorney to narrow these issues down. Once you get the prevailing wage documentation back, then you start the recruitment process. So you need to recruit in newspaper, depending on the type of company you have, newspapers, local newspapers, newspapers of higher circulation, the radio, company referral programs, the website. These are just examples to show that there aren't any US workers that are willing, able, and eligible and available to work for you. So this is where we want to prove that you're not stealing the work of another US citizen to do this job. If someone applies and they're actually eligible for the position, well, you're going to have to interview them and take copious notes and hopefully prove that they weren't eligible for the position. And attorneys work with you to guide you on how that recruitment process should go forward. Once that's done, we submit the form ETA 9098. Takes about 18 months to get that back. I forgot to say prevailing wage is taking around 6 months, 18 months to get the labor certification back. Once the labor certification is back and certified, then the employer can file Form I-140 with USCIS, the eligibility document. And once the I-140 is approved, another 6 to 8 months, depending on where the client is filing from, the foreign national can apply for the actual green card to adjust their status or AOS in the US, or if it makes more sense based on the facts to file and consular process the case in their home country, or if they're out of the country and need to consular process, then you would do that. The employer must pay for the perm process and the I-140. So must pay. They're not required to pay for the adjustment of status. And payment of fees cannot be a condition of employment. So, I'll pay for the fees if you agree to work with me. That can't happen. So keep that in mind. And if you hire someone and, their green card comes through and their green card is based on their employment with you, they are required to work for you for, I used to say 180 days, but I'm hearing attorneys say 90 days. So let's say anywhere between a reasonable amount. So anywhere between 3 to 6 months, they are required to work with you, or the green card would be in jeopardy. Let's say you're filing for the perm process and you're halfway through the perm process, you need to go through layoffs, or the employee, doesn't want to work there anymore. They need to start over at their new employer. So it is an investment, but I do these all the time. Other attorneys do these all the time. It's really dependent on how badly you want this person to work for you. Of course, if they've already been working for you on an H-1B, a TN, or O-1, another type of visa, well, you've already invested a lot of time and money into them. So it's harder to go hire a new individual than keep the employee that you've dedicated a lot of time to, and they've also dedicated a lot of time to you, the employer. So I haven't heard from Christine, so I'm assuming no questions on that end.
Not on those so far.
Okay, all right. So let's talk about immigrant visas that don't require you, the employer, to sponsor for the foreign national. And this is actually my niche practice. The O1s, NIWs, EB1s. I love doing this. A lot of writing, but I like it. So for these types of green cards, the EB2C, otherwise known as a national interest waiver, NIW, or the EB1A, extraordinary ability visa, the foreign national is not relying on the employer for the green card. And of course, on the other hand of it, the employer is relieved of responsibility for the foreign national's green card process. Now, these two types of green cards are really hard to get, especially the EB1, because that's the highest preference category. It's the EB1, the first one you see. It's hard to get these because there are specific requirements that the foreign national needs to prove. They don't need to prove anything about the employer. They actually don't even need a formal job offer to file for these, but they need to show that there's some interest in the work that they're doing. Why would you, the employer, care to know about these visas if it's not going to involve you at all? Well, because it's not going to involve you at all. So if the foreign national gets their green card through the NIW or the EB1, one, it's much quicker than doing the perm process because we're not dealing with the Department of Labor, we're only dealing with the Immigration Service. And two, you don't have to pay for the fees. I'm working on two specific cases right now for NIWs where the employer is, but by no means are you required to pay for the fees because the foreign national is self-petitioning for the green card. So for an NIW, the work and field must be in the national interest of the US. The foreign national needs to have an advanced degree or show exceptional ability, and they need to show that they're documentary qualified. So it's a big filing. It's usually like this big, the NIW that we submit. It's really, really focused on how will the foreign national benefit some aspect of the US's national interest once they enter, improve its infrastructure, technology, healthcare, culture, and so forth. The foreign national just files a form I-140 with USCIS, and then based on the country that they're from, if approved, see if the time is right for them to apply for the green card. Right now, the EB2 category is backlogged for all countries and India, China, and Mexico and Philippines. Those countries even more backlogged. But a couple years ago, it wasn't, and people could file for the green card right away once the NIW was approved. The EB1, on the other hand, is for individuals that show extraordinary ability in their fields, and a lot of documentary evidence is required for this. The regulatory criteria for the EB1 is actually almost the same as the O1, except that it's a green card. So it's a higher standard to meet just because it's a green card. Similar to the NIW, no job offer required, but need to show interest in the work and show up for both visas that you're coming to the US to pursue the work that you filed for. And Form I-140, file Form I-140 with USCIS, approve, apply for adjustment of status in the US or consular process. Why does everyone want to file for the EB1? Well, it's severely less backlogged than the EB2 categories and all other categories. If you're from all countries other than India, China, Mexico, and Philippines, or actually just India and China, it's actually current. So as 15 days after you file and the EB1 is approved, the foreign national can file for their actual green card. For India, it's a lot less backlogged under the EB1 category. It's 5 years backlog versus like 12 or 14 under the EB2 category, and China is just 2 years, I think, backlog under the current visa bulletin that comes out every month for the EB1 category. So next slide. All right, so key considerations as an employer. Compliance, compliance, compliance. Make sure that you are knowledgeable about the immigration policies and visa regulations and laws when hiring a foreign national. If you want to sponsor a foreign national for their visa or green card, make sure to consult an immigration attorney so you, beyond today's presentation, understand what your responsibilities are as the employer. Timeline, as you've heard me say, these cases can take a few months to prepare and then a couple weeks to a few months to process with the immigration service. So you need to be realistic that you can't onboard someone next week that's a foreign national. These processes take some time. Of course, there's ways to expedite the process by premium processing it, but it's still going to take some time. Costs, consider filing and legal fees. We talked about which types of visas and green cards require you as the employer to pay for the foreign national and which ones don't. Let's say you're sponsoring a foreign national, you have to pay for them, but on the other hand, they have more of an obligation to stay with you and work with you. You're not paying for them, you're not sponsoring them, they have a type of visa or green card that's not tied to their employment with you only, they can go work for anyone. But I feel like that can happen for any employee, regardless of their nationality and status in the United States. So I think just goes back to what I was saying earlier, really just understand and consider whether you really want to work with this person. Do you really like them, and are they really good at the work that they're doing? Employee support, really, really important to provide guidance and resources for your international employees where it makes sense. Of course, if you think it would benefit them to consult with an immigration attorney, leave that door open for them. And, depending on the type of case, you're on the call or they're just doing it alone. Some really good resources and contacts, and this is in your handbook. The USCIS's website and State Department's website has really important and useful information about immigration laws and policies. For the I-9 eligibility, I would just go on uscis.gov and then in the search engine put I-9. to learn a little bit more about your employer responsibilities when hiring a foreign national. And any questions that may come up, this is my email, my website. Would love to connect with you on LinkedIn, and if I can be a resource to you in the future, happy to do that as well. So that's the end of my presentation for today. Thank you so much for joining me, and I hope to connect with all of you and some, if not some of you, in the future. Okay, thank you so much. Bye-bye.
Thank you, and thank you to our listeners for joining. In a second, when we end this webinar, you'll get a participant survey. So please share your feedback there on this great webinar, as well as business law related topics you'd like future webinars on. And to sign up for one-on-one legal advice with an attorney for your organization, view our upcoming events, and visit our online resource library, you can visit lawhelp.org/DC/NPSB, lawhelp.org/DC/NPSB. And thank you again, Yalda. This was fantastic. And if you're listening, remember you can reference this back online. It was recorded, so please feel free to do that. Have a good afternoon, everybody.